I am delighted to welcome today's presenter, lecturer, the Social Justice Institute's fellow, Alireza Noorani Durgiri, who is going to share with us what he's been spending his time doing over the last year and a half as a fellow at the Social Justice Institute, and then spend a good period of time sharing his research around the United States, the bail system in the United States. Would you join me, please, in welcoming Professor Narani Dargiri?
Thank you. Thank you. Some stuff down. Okay, thank you all very much for coming out, especially on a rainy day in the afternoon, but it is very much appreciated. I am quite excited to share both my research and also demonstrate when there's mention of the Institute giving space to be able to research, it is not just a talk. I actually have a lot of space to do so and have engaged accordingly. So some people I'm meeting for the first time, some people, many more, some people don't know about my research more specifically. So just to ground us in what my research is generally about, I have a lot of discussions on intersecting areas, a lot to do with criminal law as well as civil and human rights laws. There's a lot of discussion of race, especially since there's equity considerations and all of these. So those are my overarching umbrella for considerations, which generally has led to two tracks. One is analyzing the disparate criminal law practices. The other one is discussing civil and human rights impacts as they relate to minoritized groups. For today, I'll focus on one of them. Happy to talk at length on both of them, but I will focus on one in particular. And more specifically, that area has largely become around cash bail. So, since familiarity with cash bail may not be everyone's forte, I just wanted to give a little bit of a background of why we have it, what it is, how do we set it. So generally what cash bail is comes in two different forms. Bail and bond is often used interchangeably. They're slightly different. In bond is the general agreement of conditions that relates to your pretrial release. Bail is just a specific type of it. It usually means cash bail, which is a collateral or monetary amount, so literal money being exchanged in return for someone to be released before their trial begins. The exact reason why we have it falls into two different categories. It's either to protect the public, so the defendant is accused of doing some kind of crime that potentially poses a threat to the community, and having a bond condition that would restrict ability to have pretrial release would then protect the public more. And the second one, the defendant poses a specific flight risk. So a flight risk is you leave town, you're not attending all your hearings, you're wasting judicial resources. That is another reason why that bail is set. How it's exactly set is not clear. So you would need to check your local listings as to how exactly it is set. Some jurisdictions use bond schedules. If you think of like a menu, someone who commits X crime, they will get this kind of bond condition or bail amount. And that relates to various different alleged crimes. Some jurisdictions have found bond schedules to be unconstitutional, which leads to further discussions, but that is still a way. Judicial discretion is often used, just meaning fancy term of judges will make a decision of this is what they think as fair. A lot of research has already shown that it's done inconsistently and has biases in itself. Especially recently, a lot of places will use risk assessment tools, which are data collected and will just spit out what a fair bond condition or bail amount would be. And for most jurisdictions, they use some mix of it. It's not that they just use one, or two, it's that they use any number of these in order to reach that bond condition. What eventually happens if you can't pay bail, especially cash bail amount, is you are incarcerated until your trial begins, which has collateral consequences that impact your physical, mental, and emotional well-being, as well as increases your chance of convictions, which is what other research has emphasized. It's fairly ineffective of achieving court appearances even before that. There's a lot of Eighth Amendment concerns, so the Eighth Amendment tries to protect against unreasonable bail conditions. There's increase of rearrest rates, which actually would threaten public safety when you impose cash bail amounts. There's disparate impacts on people of lower income statuses and people of color, and it gives you a larger chance of incarceration. This is the existing research that's already been done, and it's well documented. There's lots of nonprofits who do some of the empirical research work. I gave a couple examples from the Prison Policy Initiative, where they've demonstrated both the socioeconomic status issue that I briefly mentioned, as well as the racial disparity issue, where I've tried to expand on the existing literature, which the QR code links to my SSRN account if you're interested in.
Show me how.
Wow. Some sketchy websites, that's what I'll say. They'll help. But I've been able to expand. So before coming to the Social Justice Institute, I had one piece on cash bail that had already been published, where it was just generally about human rights violations with the existing U.S. bail system. And then since I have been able to revise and publish two more, so one was about the interactions between cash bail and protesting rights, and the latest one, which got officially published, I want to say a month ago, is about 14th Amendment, Equal Protection Clause, and cash bail cases, which happy to delve more into that. What I will be talking about today is mostly about my current paper that I'm revising for the spring cycle, so I will take all of your feedback and suggestions. But I have future pieces that doing all this research has led me down some holes into that I want to engage with further. Some of them are more general topics of how bail and property rights go into, but some of them are a lot more specific, such as getting empirical research on this specific access gap. What I will emphasize is I don't want this to ever seem like an academic exercise. I think whenever I get to that point, I need to reevaluate my research, because these are real issues involving real people, and there's real harm. People like Starmaine Jackson, who in this specific case was arrested and was facing her first crime that she would ever potentially get convicted of. But even at the bail process, she had to face it alone. And this is a confusing process on many levels. And even though she needed representation and would otherwise qualify for representation, no legal representation was ever provided. She would be completely on her own. She was never asked of her bail amount if it was unaffordable for her. And when she had two little kids and was only recently starting a new job, the $700 bail amount that she was given was unaffordable to be able to relate to her pretrial release. So that eventually led to her pretrial incarceration until the point that her community would be able to collect as much money as was necessary, which created a big financial hurdle. People had to take loans out from various places, and it took several months for everyone to reach even from that 700 amount. And the unfortunate scenario is this is not new. This is not necessarily anything novel that I have come up with. There's other horrifying stories like Jessica Preston, who was forced to give birth on a jailhouse floor because she was incarcerated for not being able to pay a bail amount and couldn't have access to counsel to help lower that amount. There's been several others who have lost housing, who have lost jobs, who have lost educational opportunities. And the very unfortunate part, which is also not anything new, is there's been several indications of people who have also lost their lives as a result of the emotional and mental turmoil that pretrial incarceration has. The frustrating part of doing this research is access to counsel absolutely helps, and it's fairly clear that represented defendants have significantly better outcomes and more successful outcomes for it. So Gideon's Promise is often thrown out there. Professor Hardaway, you call on students, so I will call on you. Do you want to tell us what Gideon's Promise is?
Just that that there's a right to legal representation in the criminal context, right? For individuals who are accused of a crime and the conviction is subject to incarceration. Is that fair enough?
That is fair. You get a gold star. See me after, I will give you a gold star. Yes. There's a wonderful line in this opinion that lawyers in criminal courts are necessities, not just luxuries. Not necessarily anything nice to have, it's something that everyone is required to have. So just a very brief background of the case is Gideon was someone who was poor, could not afford counsel, was being charged for a felony, had asked the court to appoint him someone. The court said they only appoint people in capital cases, and his was a burglary charge. So he eventually represented himself and was found guilty for doing so. He filed a habeas petition that the court violated his constitutional right to be represented by counsel, and eventually through all the legal proceedings that made its way to the U.S. Supreme Court. When the U.S. Supreme Court got the case, the main issue there was whether the Sixth Amendment right to counsel in criminal cases extended to the broad extent that Professor Hardaway explained. And even in the state court context and not necessarily the federal court context. And a unanimous court said yes. It didn't have any disagreement to that extent, and that the U.S. Constitution required that attorneys are appointed to defendants if they can't afford counsel on their own. This is, again, like, lawyers are not nice to have, they're essential to have, and this is particularly true in bail proceedings. Most people never reach their trial. Most people will settle or have it dismissed at some point in these proceedings, but never reach the jury to make a decision for them. And the part that almost everyone receives is some kind of bond condition, which cash bail is one of the most utilized, about 61%, and bail has become the largest driver of pretrial incarceration as a result. It inherently risks incarceration without the need of a conviction. And what I want to emphasize is, even though it's well documented, people are still legally innocent. There's no conviction. Someone is just being alleged of committing the crime. So someone may have very well have committed some kind of offense, but up until this point, there has been no for sure conviction for it. But they're treated as if they have been already found guilty. And some reports and other research has shown that these are increased. This condition of being put between a rock and a hard place that defendants face is being exploited for predatory plea deal practices by prosecutors that will exchange a shorter sentence in exchange for a conviction. Again, representation has a big aspect to it. And I will emphasize this point because 75% of defendants are released pre-trial when they are represented, compared to 25% to those who are not. This is a lot of small text and a lot of bar graphs, which I acknowledge, and it's not necessary that you are able to see all of these. The point I'm trying to bring across is that the top bar in each of these groupings relates to when someone is represented, and there's better outcomes every time someone is represented. And when you talk about judge decision that either concurs with the risk assessment or is more lenient, being 10% higher when someone is represented, there is something unique in that scenario that needs to be ensured that everyone has access to this counsel. But do you have right to counsel at bail proceedings? Professor Hill, I don't know if you want to give a guess. You teach constitutional law.
Yeah, although not criminal procedure, but I'm gonna guess no.
Okay, so I will say you are right and also wrong. So you can be both. The Sixth Amendment generally has this right to counsel, but whether or not it applies in the bail context is a little more complicated. In general, we still struggle to have upheld Gideon's promise. So this broad promise that every person who can't afford an attorney will be provided one. The data that exists has shown that we have struggled to do so, and this seems to fall into three categories. There's disagreement of whether something is a critical proceeding to trigger this right. There's disagreement of whether someone is indigent or not. And then there's the group of people who are not defined as indigent, but are also not rich enough to afford counsel. So there's this large gap of people who still can't afford counsel but aren't poor enough to fall into the appointed category. So in these three aspects, I'll take them each in hand, which I think there could be a good argument of bail proceedings being a critical stage. Other scholars have written about it. It's a interesting point that protects interest for all defendants. Coleman versus Alabama had explicit mentions that in preliminary hearings you're afforded the right to counsel, and during those preliminary hearings is to fix bail, and counsel can be influential for aspects such as bail, but circuits are still split. It's a trial-like confrontation, and it provides a meaningful opportunity to advocate for their own interests, and without doing so, a lot of judges have even told defendants that they should not speak. But still, circuits have not decided which way to go or the other, which makes it ripe for the U.S. Supreme Court to take, which I would love for the U.S. Supreme Court to take this article and cite it. That would be great for my career. But even if we fully agree that all the circuits agree that bail proceedings are a critical stage, the right to counsel generally only applies for indigent defendants, which is not defined consistently. Between Ohio and Kentucky, even, which are bordering states, they are not the same. Ohio, I believe it's about 187.5% of the poverty line, the federal poverty line. And Kentucky has a sliding scale of how much representation someone gets for free, which is there something uniquely different to Kentucky compared to Ohio? I'm not sure, but in any case, jurisdictions have not come to a single answer for it. At best, they go through what I call a mini trial in the paper. That would be at best, that would be a very generous reading of it, where a judge often just says, I have found the defendant to be indigent. But this has made it piecemeal. It's different every place you go, and you have to check, again, your local listings. And this is not a lot of money. So this is 200% of the poverty line. This would be more than what would be in Ohio, and for a household size of just one, that would be $31,300 per year, or about $2,600 per month. That doesn't leave a lot of money. This is from the federal poverty guidelines from 2025. This doesn't leave a lot of room for someone to save money for these emergency expenses if they were arrested and have to pay a bail amount of $500, $400. So even if indigency was defined consistently, someone being poor enough isn't, it still creates a problem. The frustrating part of doing this, there's no nationwide research that showed this gap between it, which is something I would love to dive into a little bit more to see, but some related data, especially with the amount of emergency savings that average Americans can have, where over half can't afford $1,000 emergency expense, that gives clues that this problem is very real. But even if we had a holistic access and a system that defined indigency consistently and that addressed that gap that I was talking about, there's been some courts that have put roadblocks in the way for defendants in receiving their right to counsel that they are entitled to, which means there is some kind of institutional change that needs to be made that avoids all financial considerations. So my fear of continuing this system is that the bail system is just going to be used to further exploit the poor, especially with how more jails and prisons are being built. So federal funding is available for jurisdictions if they build more beds to incarcerate more people, and this could be a financial incentive for jurisdictions to prevent access to counsel, because if you prevent access to counsel, more people will be incarcerated for longer. You get more funding, and you can use that funding for various other things. The proposal I make in the piece is creating an automatic bail counsel, which the general aspects of it I will go over. I'm happy to dive into any and all aspects of it, but it has to be formalized. Just as someone would get their fingerprints taken during booking, this is a formalized process where you know you will see someone immediately. They will collect your factual information that would be provided to the court to make a more tailored finding. This ensures that you have some kind of advocate for your bail proceeding, and it would have access to information for judicial consideration that is often not found at these early stages. The part I emphasize that needs to be careful about is this has to remain a limited representation role. It can't extend past the bail proceeding. In this way, it would both ensure that the advocate isn't overworked, but it also empowers the defendant to have control over the representation. If they want to substitute, if they want to waive, if they want to bring in their own expertise and be pro se, that is up to them, but at least they have the option to do so, and it's not because they're poor. And in some careful ways of doing it, even it being a limited representation role, can mean we can avoid the need of the Supreme Court saying that this is a critical proceeding or not. I will put a lot of the costs and critiques, which I am happy to go over more in detail in the Q&A. I will put them all up here, and I want to be upfront that this is not something that would be welcome with open arms immediately. There are a lot of costs and critiques associated with it, but the last one about the literal money cost is something I wanted to go into a little bit more, since this is where the bulk of my current efforts in revising the article are focusing on. So the money aspect, this is a expensive endeavor, but good investment strategy means it will eventually save a lot more money than it costs. You will need to pay these bail advocates some kind of living wage. And in doing so, the estimated costs that I have roughly come up to is about $5 million per state, or $250 million. Nationally, I would love it if it was $250. These are estimated costs nationwide. I acknowledge that New York has very different needs from Iowa, and might have different pay structures accordingly. So what I'm trying to do and the revisions that I'm currently doing is breaking this apart to see what jurisdictions might need and give more direct estimated figures. But when you consider there's about 400,000 people who are detained pretrial, and 60% of that population, stay with me, there's math, 60% can't are there simply because they couldn't afford their bail amount. That's about 240,000, and it costs about $40,000 per year to house someone at a jail. This just means that there needs to be a 2.6 change in the population. So that's about 6,250 people nationwide in order to break even to make it a successful investment. When you consider that the current bail system also costs about $14 billion a year, there's a potential that having this system that could potentially release more people would actually save the system a lot more, especially taxpayers, a lot more money, and that those $1 billion could be allocated in different ways. Regardless, even with the money, and I understand the $1 million is $250 million is a large figure, rights are not contingent on how expensive they are. Nowhere in Gideon versus Wainwright did the court wrestle with, you have the right to counsel unless it's expensive, then we'll pause it for a bit and we'll restructure our budget, and then maybe. That wasn't what they came up with. They made a broad promise that you should have the right to counsel, and that's the way it should remain. So, with that, I believe it's almost exactly 30 minutes, which was my goal. I did want to leave room for questions and feedback, especially as I am developing this further. Yes, Anne?
I had a question. So when you were calculating how much it costs to house someone in jail for a year, does that also include the loss to the economy from that person if they were back at their work and living and spending and doing all that other stuff? I wasn't sure if that was included in that
cost. So that $14 billion figure, it does not take into account the future costs. In other parts of the paper, I talk about how the consequences involved with incarceration can impact someone to, I think it's around $1 million in lifetime earnings for them, which has ripple effects in the economy because that money's not being gained, so it can't be used. So that $14 billion figure was solely in the incarceration aspect, not following.
Yeah, so I have a question. So I guess I don't know very much about this area, but I know other folks have proposed just getting rid of cash bail altogether, and I guess one question would be why not just do that? It seems kind of easier and cleaner, and does your proposal kind of intersect with those proposals at all? Is that something complementary, or does your proposal mostly rely on the idea that cash bail is going to continue to exist? Or I guess just wanted your kind of reflections on that.
Yeah, which I think is a very good point. And in my prior research, I have more emphasized about abolishing the cash bail system entirely because of all of the unfair and disparate impacts that it does have. I have tried to take a different approach for this one of accepting the system of the way that it is, and there's still work that could be done to reach the same outcomes. And the reason why I did that was the example of the state of Illinois, who got rid of cash bail, but the pretrial outcomes are not as good as people would have hoped because there still is the exception that you can deny bail for someone who is getting a bond, who is a resident and is receiving a bond condition. So even though cash isn't on the table anymore, the eventual outcome is still the same, which is pretrial incarceration. And without access to counsel early and often, you can't make the argument of, no, denying bail is actually unfair. These are the reasons why. Here are the factors that go into my client's case. Yes?
So you mentioned that the cost per year for your proposed system, which is basically like a counsel for every person pre-trial, would be about $250 million per year. How do you envision designing a kind of a system that expands representation with exacerbating existing inequalities, like urban inequalities and rural defendants? I think one of the points was it would be duplicating a public defender. How do you plan on designing a system or proposing to design a system that would be able to kind of combat some of the costs and conflicts that you like?
No, I think that's a wonderful question. So, to be clear, the 250 million is in addition to what is already existing, which that would change jurisdiction to jurisdiction. I'm happy to find those numbers for you. And especially, I'll take them in two parts. The urban versus rural aspect of it. The system I propose is admittedly not a perfect system, but a lot of the information that is gathered for successful bail proceedings, more successful bail proceedings, I should say, is largely fact-based. So that could be done through a video call or a phone call. So even defendants in rural areas could still have access to it and not necessarily need someone in the place for them. There's other issues with connection and whether or not that is a fully perfect system, which I admit. The other aspect of it was that I wanted to discuss was in relation to the already existing load for public defender systems. So are notoriously known for being overworked. There was one study that was done that public defenders would need to work something like 26 hours per day every day in order to give the comprehensive representation for their clients, which there's only 24 hours in a day, so that's unrealistic. So in making a limited representation role, it's like there is a line now. You can't then use these bail advocates for other purposes for it. Everyone will have their bail advocate, and that would be able to translate into better comprehensive representation. I put quotes around counsel because in the piece I talk about that if it's done carefully, it doesn't necessarily need to be an attorney. I agree. There's like some ethical considerations in there. Philadelphia did a interesting pilot program with something like this where the advocates went in, not attorneys, they went in, gathered that information, and then translated that information into a memo or some kind of report for the public defender so they could show up and essentially just read off of it. And that led to a lot better pretrial outcomes for defendants. So has to be carefully done. If you're doing legal representation work and you're not barred, that becomes other problems. Follow up?
Yes. So I know. So AI is like very common right now. I know there are a lot of security issues with AI, but in my opinion, the concept of having paying a person a salary to do like to be a bail advocate is, I think it can be seen as a little bit inefficient because you have somebody with knowledge, you have somebody with the ability to kind of like read through a document and say like, okay, like, or read through whatever the proceeding and everything and say like, okay, here's what we think and here's how you should advocate for yourself and here's what you can do. So I think maybe it would be considered a little bit inefficient to create a whole new position for this role. Would it be possible to kind of create and implement an AI system that would look at things kind of a little bit, obviously it would be objective. It would say like, okay, here's what you have, here's what, like, here's how you could kind of advocate for yourself. Is that something that you've thought about? Is that something that is possible?
So is it something I thought about? Yes, especially since a lot of people are at least tangentially familiar with how AI works. I think there's some training tools and education that would also need to have considerations. The reason why I don't propose doing so is because the AI tools available for it run into the same problems that risk assessment tools have. So if you have bad data that goes into these AI models, you'll get bad outcomes for it. So if you type in your demographic information in a lot of these risk assessment tools of I am a poor black man who's unemployed and a single father, you will be shown as high risk, less than low risk. And if you're using similar data for the AI tools. It's just very difficult to constrain AI sometimes, and there's other reports about AI having other racial implications. So try to avoid that aspect of it. But great follow-up piece that I can engage more in. Yes.
Engaging why we don't want AI. Yeah. So I have so many thoughts, and thank you for clearing up. The advocates are not lawyers, because that's one of my questions here. I was like, he's using this word advocate intentionally. And I only had the initial reaction that I had because I think it's unusual. Do what you want with this, right? For those of us in this profession to be thinking of ways to sort of decrease the opportunities to bring students in the door. So your cost benefit analysis for the paper might, you might just be mindful of it in other aspects. I also, the unauthorized practice of law, all of those critiques that it sounds like you're really mindful of are worth keeping in mind for the advocate standpoint. But then I think about like the Bail Project, which is here in Cleveland, and like Kareem Hinton is connected to it, and it has literally helped us get clients in my clinic released at different times, right? And Kareem, yeah, I was the lawyer, but I wouldn't have, my client would have never been on their radar but for me having a connection to Kareem. And so I do agree and understand that there's a connection for advocates in some form or fashion here. I'm trying to think of what I want to say out loud. I want to say, no, because some of it is just like it's very specific, like picky things that that absolutely don't mean anything to everybody else who's with us, but you'll be like, ooh, this is wonderful.
I'll look forward to your email.
From this piece of paper, we're gonna talk about it. But I love the framing of the real people, real harm, right? I think that frame is so critically important, and I would love for you to carry it through the project, right? Because I understand why you go to the cost benefit analysis. I understand all of that. But I think there's so much work to be done, and maybe you've done it in some of the other pieces, but as you're thinking about what this advocate could do, right? If you're not tearing down the bail system, right? Then how do advocates actually do things to meet the needs of real people who are experiencing real harm? I haven't read the piece. I look forward to reading it. But that was something that I just wanted to highlight.
Oh, thank you. I think that's actually a great suggestion, since I start the piece with story of Starmaid Jackson, and I think I can carry that on a lot more. The point about students, and so there's a part in the piece where I talk about if the investment isn't going to be made in this way, clinics can actually be a good place to have the same role because it's limited. It is it's cost effective for schools where they can train students to ask these certain questions in client intakes and be able to advocate in a quick format, and it gets a lot of hands-on experience, reaches ABA goals. So there is some success that can be done in that way too. So I appreciate that part too. Yeah.
Sorry, just jumping on that. Like, so could you currently do this? Like, could you say, like, we're going to start a clinic in Ohio, and the clinic is going to be bail advocates, and they're going to just, like, you know what I mean? Like, is there any rule that would prevent someone from bringing a non-lawyer advocate to a bail hearing to?
I'm not aware of I'm not aware if it would be that easy to implement.
So I think this is where my other point that I'll share out loud is like understanding like the check your local listings. You probably want to do a little bit more digging there so you can identify the places where this opportunity would actually be relevant. I would say in Ohio, right, for the purposes of bail, the lawyer at arraignment absolutely does get to do that. There's a window for non-serious crimes, right, that get in, doesn't touch but typically, right, those people aren't being housed pre-trial anyway. Right, so my point is Ohio is maybe not a great example. And to the extent that you want a more robust presentation at the bail hearing by the public defenders who are underpaid and overworked, right? The lawyer in me would say, why not take that $250 million, right? And more equitably fund our public defender's offices, which get a fraction of the budget, right? The funding that prosecutor's office is currently getting. And if they had more, then they could do this too, right? And I think,
Yeah, which I think is a great point too. I had thought about initially creating just a separate division in the public defender's office that would only, like, their sole role, kind of like the appellate division, except this would be, I guess, pretrial bail division for it. The concern is that even appellate public defenders don't solely do appellate work. They're brought into doing other works like record sealing. So I have a friend in the office right now, and he says it's a growing percentage that he's being brought in to do other stuff that's not.
yeah, because they don't have enough money. But if you gave them this $250 million,
touche.
right? I mean, yeah, for sure. And but thinking about it as a part of the rotation, right? That an office would use for young lawyers and or just people where it's their jam, right? I mean, I think could also be a part of the vision that you cast. But I really do think having at least a few jurisdictions in mind, right, where this is particularly relevant would help you then flesh out more pieces and parts to make people be like, he's onto something, right? Because even the things, if their jurisdiction isn't one of the things, like I understand you from a researcher standpoint, you want to say like, check your local listings, because what I have to say is really exciting, and whatever you can take back and use for yourself, then you'll be able to do that. What you know as well as I do is that nobody's going to do that. Right? Like I can't get not most of them. I have some students who I absolutely say go get it, and they go get it. And then I have other students where I'm like, right? And that's the same with the folks who are going to hear and read your paper.
Yeah, and obviously you can't do 50 states, right? Like there's no restriction to do that, right? But I don't know. I assume they're all different. But yeah, if you just find like Aisha was saying, like there's a few states where like they're sufficiently different that you can talk about them, separately, but just as illustrative, I do think that I agree that put a lot
and if you roll with this is what happens when you're right in my area. So, and if your goal is like to think about a quantitative analysis that you're adding to the layer of your research, I would put my energy and effort there as opposed to on the cost benefit analysis, because in many ways then you're satisfying both needs, right? So if I did a state survey and I said like, of the 50 states, 30 of them do this, how many states are there? Right. 30 of them do this, 10 of them do this, 10 others do this, or some combination of that, right? And then you talked about where your advocate sort of role would play in whichever subset it's most relevant to, right? Then I think your reader is kind of like, oh, he's fancy because he's done this qualitative piece or part, right? And I can look to see exactly where I sit in this, where my jurisdiction sits in this, as opposed to some arbitrary, and I don't mean that in a pejorative way, I just write like some estimates, that's the word I should use, right? Some estimates of how much it would be, something to 250 million to implement this for advocates who make, $40 an hour or whatever that, right? Because I don't think the economic piece is the most jazzed part of this proposal. I think sort of like really giving, if bail bond is your jam, this is your area, right? You know what I mean? Then demonstrating sort of your full awareness of what the scope of that looks like nationally is a good place to do, is a good place to, a good thing to have in a proposal like this, right? Because you've written several pieces on this, right? And so at some point you got to digest what the nation looks like for the people.
Happy to do so.
I liked the cost
You like the cost
benefit. Like I don't know about the 250 million. Like I feel like it does feel a little like it's hard to do much with that number. But like I do think like to make a proposal like this
without acknowledging it.
Yeah, like you're gonna like
acknowledge it.
what's powerful. Like the only way a state's ever going to adopt this is if they think it's going to save them money. I mean, maybe some blue states not, but right, but like otherwise, right? They're
That's
only
right.
yeah. So I mean, they're certainly not going to say, "Oh, I've just found a bunch of money to put toward this." And I think like you're like again, I don't know about the 250 million, but the like it costs $40,000 on average to keep someone in jail for a year. These people would make, I don't know, whatever, $60,000. It wouldn't take that many people per bail, per, advocate or something to, you could shape or describe the economic calculus in different ways. Some of it is based on harder data than other things. So, you could say it like that, but.
Yeah, right. I guess I shouldn't say get rid of the cost benefit analysis at all. I'm just saying I wouldn't get too bogged down into sort of like an economic model for it.
Yeah.
I mean, you have to understand the cost benefit analysis and see that clearly. I love the normative statement that you're making, right? Rights are not determined by costs. Mm-hmm. And I want you to put a footnote in all the ways where the system actually does say rights are determined by costs. Right? But your normative argument is like solid. Right? The normative point there is really solid. And then shame them. Shame them in the footnote.
Happy to do so.
Yeah, it's so like the challenge of writing this kind of scholarship in this moment is like,
Especially when cashless bail is being
Yeah.
executive orders.
right. Just like but also just right, like the idea, like what is politically possible is always that, like it's, it's always lurking as a question in these articles, and it's so hard at this moment. Like I feel it in reproductive rights. It's like everybody, like all the scholars in my field are just like, I don't even know what to write anymore. Why do I bother? You know what I mean? Like law and religion, same thing. Like I know exactly.
Yes, and what I always say to that, and you'll remember this, right, is, I wrote a paper about reparations, and for how long did people tell me, like, oh, this doesn't matter, and nobody's ever going to talk about it, and how dare you write this thing, right? And then in 20, whatever that was, they had a whole Senate hearing on the topic, right? So I just, yes, you have to be aware of it, and, you've put so much energy and effort into this. And as we talk about, like, making a record is super important, right?
Yeah, go for it.
I have a lot of questions about, as a layperson, because I don't know anything about this. What is a bail that's not with money, with cash? What's it?
So I think one of the popular versions of not cash is personal recognizance, which is a fancy way of saying I promise.
I promise I won't run away. Yeah. Kind of thing.
I will show up to all of my hearings. I won't endanger the community. Which is effectively what it is. There's a interesting dividing line with bail reform research that misdemeanors and felonies are completely different. There is one scholar named Shima Bauman. She does a lot of research of how misdemeanors that are seen as like not violence actually have the same problems with bail reform as felony, which are seen as more violent.
Yeah, this is wonderful. Yeah. We have, Angela, you want to tell them a little bit about your client?
In the clinic this semester, my partner and I had a client who was detained pre-trial, and a big holdup for the court there was that he would have nowhere to go upon getting out. But other than that, like, the offense wasn't violent. and he checked like all the boxes except like that last one of he didn't have anywhere to go, and it was also just misdemeanors. I shouldn't say just misdemeanors, but it was like misdemeanors. Like going to your point, so that was like a big problem.
How long did he stay?
He was incarcerated for 29 days.
So he was a homeless person?
Yes.
He's unhoused, displaced.
Because we had the initial bond hearing where the judge decided to keep him, and then we tried to sentence him the following week. We didn't get him sentenced that week. We tried to sentence him the following week. Still didn't happen. And then we went back a third time, and we're like, okay, let's do it today. Let's sentence him. And they still didn't like what we'd come up with for housing. So, okay, yep, one more. We'll come back next week. And then she just decided, okay, he'll be out on GPS. Fine, but he had to be incarcerated for 29 days first.
Lovely. I don't know if I have anything good to say about
Well,
that.
I have Angelina share it because I think, like, as you're thinking about how these issues crop up, you know, like, instead of like check your local listings, all politics are local, like from one courtroom to the next in that courthouse, right? Meanwhile, like we're in this other room and our case grad, well, they're both case grads, but our case grad, the one that we like now, is saying like, oh, you don't have a job? Great, then I'm gonna declare you indigent and I'm gonna waive fines and I'm gonna waive court costs. Have a great day.
That too is so one of our proposed solutions when we tried to get him sentenced the first time was this very specific homeless shelter. This judge hated that, which had nothing to do with it. But then
Because
yeah,
of
he
the
told me
specific
we were outside
homeless
with our
shelter?
client. In this other judge's courtroom though, there was another client who was charged with the same thing our guy was, and the judge asked the public defender like, "Oh, what's his housing situation look like?" And the public defender said, "Oh, well, right now he's staying at exact same homeless shelter we proposed. We know it's not a perfect solution, but he's working and in a couple weeks he'll have enough money to like get an apartment, but he is at this homeless shelter right now." And that judge was like, "Oh, that's fine."
Oh,
And
really? This is when we were in the hallway with the
Yes.
class? Oh my God! You didn't tell me that.
Yeah, but I just want to
No. But I'm just
Yeah.
saying, like,
But so like it is very like I think one of your points is like judge discretion and like
Yeah.
we saw that.
Yeah.
Because it was like same exact offense, same exact shelter was absolutely not okay for one, but was totally fine for the other.
it's been a wild ride this semester.
Hey, good clinical experience though.
Yeah.
I'm glad you're. This is wonderful.
Thank you all so much for coming.
Thank you, Ali Reza.
Thank you, Social Justice Institute, for giving me the space to write.
Yeah. Let's see if we can maybe we can find some way to keep you.
Yeah.
Can I kidnap you?
Yeah.